Ignorance of the law is no excuse in any country. If it were, the laws would lose their effect because it can always be pretended. Thomas Jefferson. In your opinion, is not knowing the law an excuse to break it? Take a moment now to respond to this question. Chapter 2 is going to look at defenses used in a courtroom. Let's take a quick look at an overview of defenses. First and foremost, in our criminal justice system, persons accused of a crime are innocent until proven guilty beyond a reasonable doubt by the prosecution. In our system, defendants do not have to prove they're innocent, where in other countries, defendants do have to prove their innocence. During a trial, the criminal defendant and the defense lawyer do everything they can to prevent the prosecutor from proving guilt. Most defenses consist of raising reasonable doubt about the prosecution's case. A defense attorney will cross-examine a prosecution's witnesses to bring out inconsistencies or contradictions in a prosecution witness's story, raise doubts about a witness's believability, or show that a witness's identification of the defendant is not reliable. The prosecution must establish to a jury or judge every element of the crime beyond a reasonable doubt. If the defense can keep the prosecution from doing this, then the defense wins. Now, just to clarify, there is a difference between innocence and not guilty. Innocent means you did not commit the crime. Not guilty means that there was insufficient evidence to determine you did the crime. Let's look at different types of defenses that a defendant can use in the court of law. The first type is what's known as an affirmative defense. This is if the defendant successfully establishes one of these defenses. It does not matter whether the prosecution can prove the elements of the crime or not. The first type of affirmative defense is a justification defense. These could include something like self-defense or necessity. A justification defense means the act was not wrong, it was just justified under certain circumstances. Then, of course, we have the excuse defense. Although the act was wrong, the defendant had a good reason, such as duress, insanity, entrapment, ignorance of the law, mistake of fact, or intoxication. The last type of affirmative defense is the Statute of Limitations. This prohibits prosecution of criminal defendants if legal action starts too long after the commission of a crime. First, let's look at the two different kinds of justification defenses. The first, of course, is self-defense, which is the right to defend yourself. Later on in this chapter, we're going to look at various types of self-defense. But just as a simple example, if Bob attacks Jose, Jose has a right to defend himself. See page 40 in your textbook for further explanation. I would like to point out that this does not apply in New Jersey. In New Jersey, it requires that the person has a duty to retreat first. If it is not possible for the pending victim to run away, they must have a reasonable belief about three subjects in order to constitute self-defense. Number one, the force used must be necessary immediately. Number two, the force against the person must be unlawful in any other situation. And three, the amount of force used must be necessary. What this means is, in New Jersey, the defendant must be threatened with immediate illegal violence or other unlawful action, and that action required the amount of force in which the defendant or the pending victim responded with. A defense of self-defense is disregarded if any of these conditions are not met. So, for example, in New Jersey, if someone is threatening to assault you, you have the right to fight back. However, if the threat involves the use of fists, you do not have the right to pull out and use a knife on your attacker. The use of a knife is excessive amount of force not covered under self-defense. Deadly force is only justifiable if the defendant reasonably believes it was necessary to protect himself or herself from death or serious bodily injury. Next type of justification defense is known as necessity. The person will admit to committing the act that is normally criminal but claims circumstances justified it. So, for instance, if you're speeding while bringing a pregnant woman into labor to the hospital, clearly she needs to get to the hospital as quickly as possible. Now, there are some qualifications for necessity to be met. Number one, they didn't intentionally cause the circumstances surrounding the illegal act. So obviously, in our example, the woman in labor is something that's beyond your control. Secondly, you couldn't accomplish the same objective legally. You don't know how long this woman is going to be in labor, or maybe the baby is already coming, in which case you need to rush to the hospital and speed. And of course, lastly, you need to choose the lesser evil, which in this particular example, all three requirements of necessity have been met. Earlier, we also talked about excuse defenses. There are 6 different kinds. So let's take a look at those now. The first type of excuse self-defense is known as duress. This is where threats, violence, constraints, or other action brought to bear on someone to do something against their will or better judgment. The textbook outlines 3 requirements of duress, which of course can be found on page 36. The first is that they were under an immediate threat of serious bodily harm or death. Secondly, had a well-grounded belief that the threat would be carried out. And thirdly, had no reasonable chance to escape or frustrate the threat. The second type of excuse defense is pretty well known. It's insanity. It's a medical condition that affects your judgment and you are consciously unaware of your actions. On page 43 in the textbook, there is an article with more examples. The third type of excuse defense is entrapment. It's a crime committed because the police tricked you into it. And again, there's an article on page 45 regarding entrapment. We will take a look at those a little bit deeper in future lessons. But for now, let's continue on with the last 3 types of excuse defenses. The next one is ignorance of the law. A person who is unaware of a law may not escape liability for violating that law. Or in Latin, ignoratio legis non excusat. Common law states ignorance of the law is no excuse. This rule applies to most crimes. For instance, a bank robber claims he doesn't know it's illegal to rob the bank. Obviously, that wouldn't matter. He would still be guilty. Society demands that people understand what is against the law. And isn't that the rule of law that we learned way back in the beginning anyway? Fifth, we have mistake of fact. While a person has committed the physical element of an offense, they did it accidentally. So, for instance, Jay and his girlfriend Karen are at a party. She asks him to get her purse, but he legitimately, accidentally grabs Maria's purse because, well, they're identical and they're side by side. Jay doesn't have any intent to steal Maria's purse. Therefore, we don't have all the elements of the crime present, and he can use mistake of fact as his defense in a courtroom if Maria tries to sue him for theft. Lastly, in excuse defenses, we have intoxication. It's where a person may get intoxicated from drugs or alcohol and do something that they would not do sober. Now, intoxication, let me just clarify, is no excuse for the crime, except if the person unknowingly ingests drugs or alcohol. This is known as involuntary intoxication, and this is used as a valid defense, where the person is given the drug or the alcohol without their knowledge or permission. In other words, they were roofied, and they acted out of character. They did not intend to drink. Therefore, it's involuntary. Lastly, we have the statute of limitations. This is when legal action must be brought within a period that begins from the date of the criminal act, or the defendants can raise this defense and bar or prohibit the criminal proceedings against them. And again, as we mentioned before, it prohibits legal action to start too long after the commission of the crime. So, for instance, most misdemeanors have a statutory period of 2 to 3 years. Most serious felonies like rape or robbery, they may have a longer statute of time, say 6 to 10 years, depending on the state and jurisdiction. Other jurisdictions do not have any statute of limitations for more serious felonies. So, for instance, murder. There is no jurisdiction that has a limitation on murder. Now, as for the states that do have limitations, the reason for this is because of the passage of time may obscure evidence and turn eyewitness accounts into distant, faded memories. The idea behind the statute of limitations is to help preserve fairness, and it is considered unfair to charge a defendant with a crime based on old and stale evidence. As a matter of fact, eyewitness testimony is one of the most unreliable pieces of evidence that can be relayed in a courtroom. Now, a couple of things can actually stop the statute of limitations from running out. So, for instance, if the defendant flees the jurisdiction, the statute does not run while the defendant is in hiding. If a charge is brought against the defendant within the statutory period, the statute is also stopped. So these are just two examples of when a statute can be paused. Let's take a little bit deeper into this and talk about DNA. DNA evidence has also impacted the statute of limitations defense because DNA does not fade over time, whereas eyewitness accounts do. It is viewed as the most reliable even many years after the crime. Laws regarding DNA evidence are still in its infancy, but the law states that the limitation periods restart from the date the test identifies the defendant. In Title 18, Section 3297 of the U.S. Code, it states that a defendant cannot raise a statute of limitations defense if he is identified by using DNA testing. California law, the statute of limitations stops running when the arrest warrant is issued, and that names or describes the defendant within the same degree of particularity required for a complaint. So in 2010, the California Supreme Court ruled that an arrest warrant had described the defendant solely by his DNA profile and was sufficient enough to pause the clock on the statute of limitations. Take a look at page 39. Which defense is valid? There are several examples of hypothetical situations. When you look at these, you're going to apply the information that you've learned about different types of defenses that a defendant can use in the courtroom and see which one fits and which one's most reasonable. Take your time now and go ahead and complete that activity on page 39. And remember, if you have any questions, you can always ask me.